and the application was heard in ACC 20 of 2019. It was the arguments of both Kilukumi and Murkomen that accused one had cooperated with the police on the 7 times he was required at the DCI, whereby he spent over 40 hours. Further, all the accused are Kenyans who have permanent abodes in Kenya. Though facing serious charges, they still remain allegations, and bail bond should not be such that it curtails their liberty. For the accused in ACC 18 and 19 of 2019, these are ordinary members of the society who did not confer any benefit on themselves, and they live on very meager salaries. They are patriots who are willing to finalize the case as soon as possible. That the court should not take away that which has been laid down by case law. That sometimes, as has been seen in other cases, people who are required to deposit large sums of money do deposit large sums of money and abscond. They requested for reasonable bail terms. Mr. Taib, who did not object to the application by the defense, argued, though, that these accused persons worked for their own benefit and DPP does not seek for retribution. That the amount of money the public lost was immense and colossal, and he sought commensurate terms to the money lost. He made propositions to the defense, which the defense accepted, and I will outline them shortly. In ACEC revision number, that is Anti-Corruption Economic Crimes Division revision number 7 of 2017, there was a complaint against the court's ruling on the requirement to admit the accused persons to a bond of Kenya shillings 150 million with a surety of similar amount, or a cash deposit of Kenya shillings 100 million. While holding that Parliament urgently needs to look at the provisions of the Anti-Corruption and Economic Crimes Act, that's ASECA, if any inroads against corruption are to be made in this country, Mumbi Ngugi J reduced the bond term to Kenya shillings 30 million and a surety of similar amount, and in the alternative to be released on a bond of a cash bail of Kenya shillings 10 million. There was the argument that not all accused faced the same charges, that some of them did not confer benefits on themselves. On the other side of the coin, the other argument is that accused should be subjected to the terms commensurate to the money lost. This is where the catch is. In our laws, there are no particular guidelines on bail and bond terms as concerning anti-corruption cases. Anti-corruption courts have to grapple with the subject wherever these issues come up in exercising their discretion. As from previous amounts that involved in corruption was in thousands, it moved to millions, now it's at billions. How is the anti-corruption court supposed to behave towards these changes? According to Mr. Kilukumi, the court should not take away what has been laid down by case law. As observed by Mumbi Ngugi J in ACEC Criminal Revision number 13 of 2019, she said, "We are in a familiar yet uncharted territory. When it comes to corruption and anti-corruption prosecutions, we are familiar with corruption because, as this court observes in the case of Lenol Kulal and Lumayete, it wreaks havoc in our society and economy and on the rights and needs of the citizens." She also observed in the above case, that is Criminal Revision number 13 of 2019, that, however, it would not be surprising if, for instance, a person charged with committing a particularly heinous or vicious murder or of a particular particular egregious theft of public resources was denied bail or bond on the basis that fostering public confidence in the administration of justice was a compelling enough reason to deny bail. Further, while the court did not categorize the accused in groups or term the basis of the categorization as a subject matter, there is an underlying thread that the higher the amount of funds that a person is charged with misappropriating, the more severe the bail or bond terms ought to be. I believe that there is a reasonable rationale for this, which emerges from consideration of the grant of bail in other offenses. While both a person charged with affray or simple assault and a person charged with murder have a constitutional right to bail, no one would argue that the same bond terms should apply. Having observed what the Honorable Mumbi Ngugi J said, I now move to the particular charges in order to help me on how to categorize the amount of bail, having considered submissions from both sides. I proceed as follows. In SEC 18 and 19 of 2019, this count 2 involves accused 1, David Kipchumba Kimosop, accused 2, William Kipkemoi Maina, and accused William Kipkemoi Maina and Paul Kipkoech Serem. The amount of loss was in excess of 93,0757.14.96 euros. These accused are admitted to a bond of Kenya shillings 50 million with one surety of similar amount, or to a cash bail of Kenya shillings 12 million each. Accused 4 to accused 16 who are charged with abuse of office and failure to comply with various sections of ASECA are to be admitted to a bond of 5 million with one surety of similar amount, alternatively a cash bail of Kenya shillings 2 million. Accused 17 Geoffrey Mwangi Wahungu, accused 18 Walinya Ongare, accused 19 Boniface Mamboleo Lengisho, to be admitted to a bond of Kenya shillings 2 million with one surety of similar amount, or alternatively a cash bail of Kenya shillings 750,000. In SEC 20 and 21 of 2019, the court moves as follows. Accused 1, Henry Kiplagat Rotich, and accused 2, Kamau Thuge, each to be released on a bond of Kenya shillings 50 million with one surety of similar amount, or a cash bail of Kenya shillings 15 million. Accused 5, Kennedy Nyakundi Nyachiro, accused 6, Jackson Njau Kinyanjui, David Kipchumba Kimosop, to be released on a bond of Kenya shillings 30 million with one surety of similar amount, or alternatively a cash bail of Kenya shillings 6 million. Where I have included some of the accused who have not taken plea, their release order will be signed and approved on the satisfaction from the IO that they have reported to the DCI and have been processed. All accused to deposit their passports and all their traveling documents in court. As argued, if they left their passports behind, they are accorded 48 hours to surrender the same. Otherwise, if they meet conditions of release, they will be released forthwith. The places of work of accused persons are considered scenes of crime, and they should keep away. If there is any need to visit their places of work, that should be done in the company of the IO. All accused should not approach any witness in any manner for whatever reason. Such actions will lead to cancellation of bond. Each accused is required not to destroy any evidence in whatever form. If adequately brought to the attention of the court, such bond terms will be revoked and such accused will be denied bail till the determination of the case. I should not have said this, but let me say it. No counsel should come to court without proper instructions. In relation to Mr. Anami, you make sure you come with sufficient instructions so that you proceed. Both prosecution and defense counsels to exchange email addresses by each appointing a key person of contact. The DPP/DCI to supply all statements and documentary evidence within the next 14 days. Pre-trial compliance to take place on 8th July 2019. That will just be compliance. After that, we'll set a date for a pre-trial conference. 8th of August, yes, sorry. Thanks for that. So all accused not present today and who have not taken plea to organize themselves to appear before the DCI, latest 26 July 2019 at 2 p.m. In default, DCI is at liberty to pick warrants of arrest. For those who have not taken plea, the plea is slated for the 29th of July 2019. Those who took plea are at liberty to stay away. So compliance is on the 8th of July 2019. No, okay, 8th of August 2019. That is the ruling.
Second plea.
Sorry, Your Honor, I beg your pardon. Yes. When you were mentioning the cash bill or the terms, you didn't say anything about accused number 3 in the case number 3.
Yes. Yeah. Case number 3, yes. 3.